Alright, ebusian for mamda mu na masi emfambre ye channel yiso. Medo bibiasi ediba ye channel yiso. Na masel say notification button ehun hia me ye pa obetene ne on. Say the updates bebia onso nsa be den e be ka no ahwe. Na bibia aye kama. Say the news e mu hwam na ye de bra mu. E brentima nyibre. Yenkotie ensem kakra ekoso.
Omo say Chief Justice removal no e grounded in law no. Nebi kan a first petition akoye bra na nado danko akofo adoteso say Chief Justice atutu kwan ni kunu ni ayia eye judicial travel policy ayede eda honom ema judiciary for Chief Justice nena se for policy eda ho. Now grants akwaku ansans ay kwaku asarewezi ye Professor Asarewezi ye ewo ni petition ni mo ye dismiss ye no. The same grounds and Daniel Ofori ewezi ye ni ewo ni petition ni mo ye de dismiss Justice Araba Esaba Tokuno. And my question is, more lawyers no so far more divided opinion in this issue no. A first petition with the same grounds you dismiss it. Not the same person, the different person. I repeated the same petition to a new president Awaba. I'm not going to say after the premier first case room. Moreover, and I'm casting my mind into the issue of estoppel res judicata mana. Say asema yedida. The same grounds, the same issues against that same party. Yetimi litigate case ya yakwa nusu. The only difference I said this time no one party exercise but the same grounds, the same issues, the same format, the same allegations. I dismiss under Akufo-Addo pension need basis with a proper legal reasoning. No, yet to me repeated the same issues, no, with a new president in office. And I already at this time, no, sir, previous petition with the same grounds, no, and they are frivolous, no, and then new president by Benya grounds. I'm ready to remove more revert more back to more mind to the issue of estoppel judicata mana. You be some because you have to put your mind on that issue. Sa sema yedi dano President Akufo-Addo pension issue should be see here na say bogua President Muhammad to me back ever relitigate those issues no succeed dia ababa ya president say president bia obaba in the future bia no any decisions bia President Muhammad beteki e wo dubri house wo bia no obi so to me then a review a setting aside a restore a reinstate. Now my catcher say there are other petitions here. Moba conclude Chief Justice no petitions na mienu aka Chief Justice no wo file petition no say oye Chief Justice and no file tia no ongoing. Now the Chief Justice has been removed. And this all petition na aka mo say mo kwa on what basis? You file a petition against Master Chief Justice. 3 petitions. But imagine so they are removing. Mo say the aka no. Mo ba face date no kwa on what basis? Because you file a petition to Master Chief Justice. Me ametiye. Say ye mame Araba Saba Toko no betie over 7 years to retire as a justice of the Supreme Court per the constitutional requirement he's supposed to retire at the age of 70. Onime betiema because so kind petition no kind year. Na se wo use proper legal reasoning na nya propaganda na obe attach to it there. Petition se wo de call ye no was about her office and her position as a chief justice. All the 3 petitions were about the position as a chief justice. And yet, say, as a justice of the Supreme Court. Because most position as a chief justice, and ordinary 2 years and he should be removed as a chief justice. And they are removed. And as a warrant, the warrant issued by the President John Dramani Mahama on 1st September 2025. The warrant clearly no one said the chief justice was removed as a chief justice. Yamame Araba Esaba Tokono was removed as a chief justice and not as a justice of the Supreme Court. The warrant, I am so vivid on that. And Timua Monka say, I will lose media legal reasoning or more propaganda legal reasoning do my man for man no munyadwini. So we find the proper interpretation of even the warrant now. Say she was removed as a chief justice and not as a justice of the Supreme Court. And therefore Yamami Justice Araba Esaba Tokono should stay as a justice of the Supreme Court. Silano or position at the Supreme Court. And Obetuma resume Aduma and Nek. Because President Mahama and remove as a justice of the Supreme Court. Now the position ye appointee no ana yam fan say yaji ayede afri ninsam. So that officer all kwakoya Aduma like any other justice of the Supreme Court, that office is still there. And me de obetie me a onko no nkonko tenam no nya na Aduma said the justice of the Supreme Court na on retire na onko fie onyame ne mre ena ye mrepa na se ye sha obi achi ema nipa no edi trogu so a ye sha obi achi edi atata to so a onyankopon fa ne bo a onto ntem na mom ye na mo sie ye nipa de bibi bia ebeba ye wo life no bia no esese tenase ni ebisa se edie na me ye ya saa de we eto me nti otie me a onya gidie won anim say ebeye no nkoye na Aduma as a justice of the Supreme Court. No nkofi after all or start ayi High Court and wabrumu akọ Court of Appeal and odi akọ Supreme Court. Enti onkonkoye na Aduma na nyame boa na nyame mana hoden ebo no ho ban nyame so be mana hoden emu oduru nyame be mana kokuduru emu oduru nyame be mana kumapa akuma foforo ba wohoro na kuma amma no one na busua no nyina hoden foforo no de akwakoye Aduma as justice of the Supreme Court on tramu enyinasem na onko no de mafutu na nyame mre ene ye mrepa yasem nyina ye de ewitim
Chief Justice Gertrude Araba-Tokono is putting up a fierce legal battle against her dismissal as a justice of the Supreme Court. She argues that the president overstepped his authority by not adhering to the constitutional procedure outlined in Article 146. She is seeking to have the presidential warrant of removal squashed, deeming it unlawful and void. Well, let's give you more on this. Joining in the studio is Colin Zublin of our recent Dex, who joins us just to tell us more of this petition. What exactly is she seeking?
And yeah, so the removed Chief Justice has gone to the High Court and she's seeking 4 main relief. So let's go to the release first. She wants the court to declare the president's power, to declare that the president lacked power to remove her as a judge. So she has considered that the president could remove her as a Chief Justice, but not as a Justice of the Superior Court. So she has considered that, yes, you can remove me as the Chief Justice, but not as a judge at the same time. So that's the first ruling being solved. Now, the second is declare that only Article 1464. Now, this is the part of the Constitution that outlines how you remove a Justice of the Superior Court, not a judge, and also quash the president's removal warrant. So now we understand what she's looking for. We have to understand why she's looking for this. So she says that the petition that was submitted, I remember 3 petitions were sent. One by Daniel Fury, one by a police officer, and by Shining Stars. So these 3 petitions, she says that all of them were for her removal as a Chief Justice, not a Supreme Court Justice. So all the petitions that eventually went to the Council of State, and the Council of State found the prima facie based on the petitions, which were again as removal of Chief Justice and not a Supreme Court Justice. She also says that when she had to respond to her, when she went for the committee hearings, she also wrote a response to the presidency and the Council of State. Her response was defending her position as a Chief Justice and not as a Supreme Court Justice. So it would be unfair for them to remove her as a Supreme Court Justice as well as that. And also, authorities have to know that the Council of State prima facie decision was only for the removal of a CG and not a Supreme Court Justice. Then again, the committee that the president set up, the 5-member committee, was set up based on the grounds to remove her as a Chief Justice and not Supreme Court Justice. And if you want to remove a Supreme Court Justice, a committee will be set up by the Chief Justice and not by the President. So she said that this committee was not set up. And if this committee is not set up, you cannot remove her as a Chief Justice, as a Supreme Court Justice. Sorry. And then finally, the committee could not recommend removal as a Supreme Court Justice because this committee was created to remove her as a Chief Justice. And if you want to remove her as a Supreme Court Justice, you have to follow the steps in the Constitution to set up a different committee that will be constituted by the Chief Justice to decide over that issue.
Thank you. The bar president here, Mrs. Efuagati, and the Attorney General here, Dominic Ahini, clashed and locked horns at the bar conference over matters of Article 146. Now, the Attorney General spoke first, I believe, and he was concerned that the bar is raising issues about the Article 146 process that removed Gertrude Tokono, and that he thought that they are being self-serving. That was a word he used, very harsh. And he also thought that they are being selective because, according to the Attorney General, when Article 146 processes were applied against the former Shraj boss, Lamte, for their first name, and is it Matilda, something Lamte, and it was also applied against Salot Osei in 2017. He, the Attorney General, says he doesn't remember the bar making any statements about it. He wonders why, therefore, that Article 146 is being applied again against Gertrude Tokono, and it becomes a problem. So that was what he said. But there was a lot more infighting and controversy about the bar conference. After the Attorney General spoke, he left. He didn't continue to sit at the bar conference. He left. We don't know what to make of it. We don't know whether we should say it suggests that he was quite angry, or there's bad blood, or there's concern about difficulties in relationship between the learned Attorney General, who is the leader of the bar, and the Ghana Bar Association, which is led by Efuagati. We're digging into that and give you some more information. But all the lawyers said that after that Attorney General left, which is unprecedented, is sufficiently uncharacteristic. But we don't know why the Attorney General left. They have had a very good reason for doing so. But he left the bar conference, and Efuagati and the rest are still continuing. It's a 1 week long activity, so they are still in doing the bar conference. Let's begin with what the Attorney General said. This is what he said.
Immediately upon assuming office in 2017, an Article 146 petition was filed for the removal of the chairperson of the Electoral Commission, Mrs. Charlotte Osei, and her deputies from office. The bar saw no basis to speak out about compliance with due process. But in recent times, the bar found its voice when petitions based upon the same constitutionally defined procedures were brought in respect of the removal from office of the former Chief Justice, Mrs. Gertrude Arabatokono. Ladies and gentlemen, the honest question we have to ask ourselves is, what changed? The three petitions aforementioned touch and concern officeholders of three constitutional bodies critical to the sustenance of our democracy. The independence of the three institutions has been guaranteed by the Constitution. The three occupants were all women of significant repute and members of our noble profession. The three committees established pursuant to Article 146 complied with the constitutional procedure to the letter. And yet, the bar found its voice only in relation to the third petition. Coincidentally, the voice of the bar amplified the voice of the opposition. The lawyer in politics must be a voice of reason, moderation, and constitutionalism. The bar must speak out not to please governments or opposition parties, but to defend the rule of law, the independence of the judiciary, and the rights of the ordinary citizen.
The Land Attorney General said that the Bar Association, I'm not sure whether the Land Attorney General at the time he read his speech was aware that the Bar President was going to talk about what the Bar considers unfair in the processes that we will get to talk about. But let's listen to what the Bar President said. Here it is.
The Constitution of the Ghana Bar Association enjoins us to protect the independence of the judiciary. This is a duty that